Hi, everyone. Thanks for joining us. I think we'll give it a couple more minutes for everyone to join, and then we will be able to get started. Hey, everyone. I think we'll give it just another minute or two for a few more people to join, and then we will go ahead and get started. Thanks for joining us today. Okay, I think we can go ahead and get started, and then it'll just be a little intro at the beginning anyway, and then people can continue to join. Hi, everyone. My name is Shloka Krishnan. I am the volunteer coordinator at the AIDS Legal Referral Panel. Thanks so much for joining us today as we kick off our spring MCLE series. I'm very excited to have WookSun Bill Hong here today with us to present on civil restraining orders. Just an agenda for today's meeting. I'll do a little overview of ALRP, how our referral process works, what the panel's like, in case any of y'all are not already involved. We would love to have you. And then we will move into the training, and we will have time for Q&A at the end. And then this is important. When you leave the Zoom meeting, a screen should pop up with a link to an evaluation form. Please make sure to complete that evaluation form, because that's what will prompt me to send you a certificate of attendance for MCLE credit. So make sure to submit that form. It's not automated, so give me a day or two. But yeah, make sure to submit the evaluation, and you'll receive a link tomorrow as well if for some reason you can't access it today. Or I emailed everyone out the slides, so you should have my contact information. Feel free to get in touch. So just some quick housekeeping. The training's being recorded. We will share the recording out once we're done. Feel free to answer any questions into the Q&A function. and we will address them during or after the presentation. As I mentioned, please complete the evaluation form, and feel free to reach out to me with any other questions. So a quick introduction to the AIDS Legal Referral Panel. We were founded in 1983, and we just marked our 40th anniversary year last year. Our mission is to help people living with HIV or AIDS maintain or improve their health by resolving their legal issues. When we were founded 40 years ago, really what we were doing was drafting emergency wills for people who were dying very quickly. Thankfully, the landscape has changed since that time, but there's still real challenges associated with managing a chronic health condition that can be exacerbated by stress, by housing instability, by poverty, by immigration status, and so on. So that's really what we are working to address by connecting people living with HIV in the Bay Area to the sort of full array of civil legal services to help stabilize their lives. We do that in two ways. So first, we have a team of about 13 in-house staff attorneys. Most of what we can handle in-house is housing related. So we have a pretty robust eviction defense program. We do other housing work. We have a couple of like sort of more general purpose attorneys. But for a lot of legal needs outside of housing, we really rely on a panel of volunteer attorneys who we can refer our clients to. We have several hundred active attorneys on our panel who are willing to accept referrals from us. And their expertise really runs, the full scope of civil legal services, which is great because, we can sort of identify someone's legal need and identify someone with expertise in that area and connect them to get the help they need. Just some quick numbers. Since our founding, we've handled almost 100,000 legal matters for our clients. These days, about 80% of our clients are living on an income of $30,000 or less. So the free and low-cost legal services that our panel attorneys provide are really critical. Most of our clients identify as LGBTQ, most are people of color, and given sort of the changing landscape in San Francisco of like transmission and so on, the majority of our clients are over 50 as well these days. Happy to note that 92% of clients were satisfied with their services last year. That's always great. So just a quick pitch. Our goal in offering this MCLE series is twofold, right? So first, we really are just, sharing resources, increasing attorneys' capacity, so on. But second is we really are hoping to recruit new people to join our panel and to help meet our clients' legal needs. So if you are not yet on the panel, we hope you will consider joining. I think many of our panel attorneys will attest that it's like been a really positive and meaningful experience for them. And a good way to give back to the community. And it's also as small or large a commitment as you'd like it to be. So in general, we ask the panel attorneys accept 2 referrals a year, but you always have the opportunity to say no. You always also, of course, have the opportunity to say yes. And just quickly how the process works is we'll conduct an intake with the client, identify their legal need, do a bit of matchmaking to find an attorney, reach out to you with a pitch on like, is this something you can help with? If you say yes, we'll connect you to the client and you can take it from there. All of our panel attorneys are covered by our malpractice insurance. We can connect attorneys for mentor support if that's necessary or useful. I think overall it's a solid system, and we would love to have you involved if you are not already. So please do reach out. There's also more information on our website. That's the end of my little pitch. One more quick thank you to all of the like bar associations and partner organizations who are co-sponsoring our MCLE series. I think many of you probably heard about us through one of their listservs, which is great. We love them. Hooray. Okay, moving on. Excited today to have WookSun Hong here with us to present on civil restraining orders. He is part of the Bay Area Legal Incubator, a group of attorneys that provide legal services for mid to low income communities. Their practice areas cover employment, immigration, estate planning, real estate, prisoners' rights, and more. WookSun personally handles real estate, landlord-tenant business law, estate planning, restraining orders, and other general civil matters. He graduated from Seoul National University with a bachelor's degree in chemistry and pursued a PhD in biochemistry before switching to law. He is the recipient of the Alameda County Bar Association's 2019 Distinguished Service Award, a recipient of the Extraordinary VLSC Volunteer Award, and the chair of the Alameda County Bar Association Lawyer Referral Service Governing Committee for 2024. He was also selected as a Rising Star by Super Lawyers 2020 through 2024. He enjoys cycling and traveling as well. And we are very excited to have him here today. And with that, I will hand it over to WookSun.
Thank you, Soroka.
And I'll share your slides too. Give me just a second.
Okay, we can skip first few slides and let's get to the slide 4.
Are you seeing that now? Is that the right?
No, that slide 4 that has the important notice.
Okay.
Yes.
Sorry.
So this is a disclaimer that comes with pretty much every MCLE, and just because you are here doesn't mean there's any attorney-client relationship, and also this is not a legal advice, and the view of this presentation doesn't reflect the view of the AARP. Okay, that's the general disclaimer. And next, Civil Harassment Restraining Order. This is usually done improper, so attorneys don't usually handle this except a few cases. If you have been to any CHRO courtroom in San Francisco, Alameda, you will see there are dozens of cases, but only a few cases have attorneys attached to it. So it is designed to be very simple and straightforward. But the law is very skinny, but because there's so much discretion given to the judge presiding the case, it's not that easy for attorneys, actually. I will explain it a little bit more later. So what is CHRO? It's an order from the court that prevents preventing an aggressor from harassing someone else. So either they can be verbal harassment or physical harassment. But what's important is it's preventing something in the future. So you cannot bring a CHRO petition to punish something that happened in the future. So if that's your goal, to punish someone for what he or she did in the past, that's not the CHRO is for. It's for the purview of this proceeding is to prevent certain harm happening in the future. And we'll discuss a little more about the next slide, please. So what is harassment legally? It's the threat of harm to the body or reputation, series of conduct intended to annoy or harass without any legitimate legal purpose. The first part is very easy, but the latter part, without any legitimate legal purpose, that's a tricky part. So what does that mean? So many people perceive certain act as a harassment. They may be right, but whether that act has any legitimate legal purpose, that's debatable, and that should be analyzed by case. For example, I handle many landlord-tenant issues, and tenants complain saying, oh, my landlord keeps sending me text or email asking me to pay rent, or my landlord send me a few notice to terminate tenancy. I'm sure they perceive them as a form of harassment, but whether they have any legitimate legal purpose, that's case by case. If you're not paying rent and landlord sends you 3-day notice, that's not, that may be harassment, they feel like harassment, but that cannot be prevented through CHRO proceeding because that has a legitimate purpose. But sometimes it can go beyond reasonable limit, then there can be a harassment. So that whether certain act has any legitimate legal purpose or not should be analyzed by case. And another point I mentioned earlier, it's to prevent future harassment, preventing future conduct. So you have to prove certain conduct, certain harassment gonna happen in the future without the CHRO. So for example, landlord-tenant issue in the setting of landlord-tenant or even roommate setting. Say your landlord, your current owner is trying to sell the property, and then he comes in all the time to show the place and harassing you. And then you decide to file a CHRO petition, and then the landlord sold the property and the new owner bought the new place. Then there is no point of having the CHRO against the previous owner because that situation is gone. So CHRO petition is for the future event, not to punish or do something about what happened already. So you have to show without the CHRO, those conduct or any harassment can happen in the future. And the violation of the CHRO is a criminal offense, and technically, if you call the police, and the police can arrest the aggressor or violator. Whether that actually happened, that really not, there's no clear answer to that. Only thing I can say is you can ask the police to arrest, you can ask the police to arrest the violator, but whether the police can actually arrest that aggressor or not really depends on the situation and depending on the city you are in, yeah. So that, but technically, you can call the police and police can arrest the aggressor. What can a CHRO do? It can prevent the restrained person from harassing or threatening you. That's kind of abstract, but it can prevent that restrained person from contacting you in person, over the phone, via email, or sometimes, I mean, more common now, by posting some stuff about you on social media, such as Facebook, Instagram, or Twitter, things like that. Those kind of harassment is quite common. So you can prevent that person from posting something about you. It can also prevent that person from coming near your home, work, and school. And of course, you can prevent the person having a weapon. Yeah. Also, you can include other people in your household as a protected person. Let's see. What can a CHRO not do? That's also very important. In the landlord-tenant situation or roommate situation, they try to use the CHRO process to evict evict a tenant or roommate. That's not what CHRO is designed to do or can do. That's beyond the CHRO court jurisdiction. So if your client tried to evict the roommate or the tenant using CHRO, it will be rejected all the time. So, but it's very common. You will see it very often, actually, unfortunately. And CHRO is an injunctive relief only. You cannot get damage from CHRO petition. So it's an injunctive relief to prevent future harm. No monetary damage allowed. So if you think, I mean, I'm talking about people filing the CHRO. If you think you can get some damage from this proceeding, this is not designed to do that. And it cannot also force the person to go to a rehab or modify child custody or child support or visitation, because some people do try to do that. And if you do any CHRO proceeding and before the court start actual hearings, the court usually let them know there is a mediator available, and then strongly suggest parties to go through mediation and resolve the dispute through mediation. First, I mean, I think it's actually a very good idea in most cases. First, there's no guarantee what's going to happen. As I explained later, there's so much discretion given to the judge. You really cannot predict the outcome. And second, there are many things CHRO cannot do, as I explained here, and then some more. But if it's a private mediation agreement, you can be a lot more creative. So you can even have the aggressor pay you some money. So through the private mediation, unlikely, but you can. And also you can have the aggressor, the restrained person, to go to rehab if that's what you really want. So the mediation is usually a better route rather than insisting on a hearing. Who can file for a CHRO? The person who needs to be restrained is a member of your household. You need to file a domestic violence restraining order. There is quite a bit of confusion or overlap between DVLO versus CHRO. So domestic violence, so domestic doesn't mean just people living in the same house. So roommate situation, they are living in the same house, but that's not the domestic violence restraining order domain. That's the CHRO domain. So but for example, if it's a roommate, CHRO, but they are boyfriend, girlfriend, boyfriend, I mean couple in a way, even though they're not married, that's a domestic violence restraining order domain. So some people file the wrong form of petition. When they need to file DVRO, they file CHRO, vice versa. So they should be clear. CHRO is not, I mean, it's for unrelated people. And domestic violence restraining order is for related or same household. Also, but that doesn't mean you can file a DVRO for, I mean, against relatives who's living far away from, like your aunt living in a different city. They are related, but that's not the domestic violence restraining order, that's a CHRO. And another restraining order is a workplace restraining order. This is something your employer can file to protect his or her employees. So even though the people to be protected is an employee. So in workplace restraining order, the petitioner is not the person who's being harassed. It's the employer. So there's a kind of new development this year. So I will explain a little bit more, because usually workplace restraining order was the scope of workplace restraining order was very limited for physical violence or threat. Now it expanded this year. Okay, and also that's another thing. So let's say you're a cashier in a restaurant or server in a restaurant, and then there's a customer harassing you. Then that sounds like a workplace restraining order, but it's not. If you want to file a restraining order against that customer, you need to file a civil harassment restraining order. Your employer can file workplace restraining order there. Okay. And this is, oh. Floka, can you put the audience poll?
The poll should be up now.
Yeah, I see.
Let me know when you want me to end it and share the results.
Yeah, you can end it. I think it should be done by now. Yes, it's the last one. As I said, you cannot use CHLO to evict anyone. Eviction is a totally different proceedings. CHLO, that's way outside the CHLO domain, but unfortunately, people try to use CHLO to evict a tenant or many times the roommate. And also, you cannot evict your roommate. Master tenant can evict a subtenant, but if you are just roommate, co-tenant, you cannot evict your roommate. The most you can do is getting a restraining order against the roommate. And in the roommate situation, it should be about 3 yards. Yeah, so that's the best you can do. So you should find a way to coexist, or you should find a way to change the roommate, unfortunately. Next slide, please. Civil harassment restraining order is designed for everyday people, laymen, to do it on their own. So there are forms, well-developed forms. You can go to the local therapist center in San Francisco, KCT Access Center, and get the form, and they usually have the packet. And you can, if you know if you Google civil harassment restraining order, you can download from online, or if you have a CV account, you can go to the CH civil harassment restraining order. You can get the whole set of forms right there. And filling out the form is also very straightforward. It's very detailed. You can ask what happened, what the future, and what was the past harassment issue ask very detailed information. So other than some exhibits to support your allegations, you don't really need that much. And also, since you can bring the exhibits or evidence at the hearing, the filling out the forms are very straightforward. And many people who feel really threatened or worry about, they need a temporary restraining order until the hearing. So don't forget to fill out CLAT and then TRO forms. And getting the permanent restraining order will be decided at the hearing. So it really depends on how good your evidence is, how convincing you are. But getting a TRO is purely based on what you put on the paper in the petition form. So I think that's where attorneys can help the client the most. So the client doesn't really know or not very experienced how to show the situation, so how to explain the situation more clearly so that the judge can decide what's going on. So I think that's the part attorney can help their client best, so that the client can show just on the paper alone why they need the restraining order. So you will see restraining order denied for lack of evidence or things like that. I think that's where the attorney can help the most. And filing fee, it can be waived if there's the violence and threat. And usually, once you file all the paper, including TRO request, you can check whether TRO is granted or not the next day. And that's when you get all the forms or the papers from the court, and then you should serve those forms to the restrained person. That's why it's a little bit different from the regular civil action. When you file a regular civil action, even including small claims or the UD, when you file, you get the endorsed copies that you need to serve on the other side the same day. But in restraining order situation, especially when you requested TRO, you have to wait until the next day, because TRO is, you don't know what happened to the TRO, so those endorsed forms don't come out until the next day. So you have to wait one more day to get the papers to be served on the restrained person. And as far as I know, the clerks, civil clerks, give you a packet to be served. So packet for the restrained person and packet for the protected person. So you serve the packet for the restrained person, which include petition and notice of hearing and the decision on TRO. And also, it's mandatory to use the judicial counsel forms. So many situations, even though there are judicial counsel forms, some lawyers use their own the pleading paper and then they write from the scratch. But in CHRO situation, you have to use the judicial counsel forms. Next, please. Next slide, please. Okay. Like any civil action, you have to serve the papers and you have to file the proof of service at least 5 days before the hearing. So if you go to the CHRO court, judge will go through the cases and say there is no proof of service filed for this case, so it's continued. So if there's no proof of service filed, and that shows the restrained person was served at least 5 days prior to the hearing, it will be continued. And unlike other civil actions, no substitute service is allowed. It has to be in person. The same thing. And also, you hear people saying, I cannot find this person, and then asking the court to help. No, that's your responsibility. Court cannot and will not help you find the restrained person. So, like many lawsuits, if you cannot find the other side to serve the papers, that's your problem, and you should find a way to serve. And if you cannot find the person, in my opinion, there's no danger that that person gonna abuse you later, although that depends actually. I had a case, a homeless person was harassing my client. So even though we had a hard time finding that person, my client was continuing to be harassed. So yeah, but still, finding the person, the restrained person is your responsibility. And if the person to be restrained refuses to accept the paper, throw away the paper, it doesn't matter. It applies the same, the general rule on service applies here. So if you find the person and then refuse to accept, that's a proper service. You can just leave it, and whether they take it or not, that's up to them. And of course, once the service is done, someone has to fill out the CH200 and file it. And it's not a bad idea to ask the sheriff to serve, but if it's tricky, it's better to hire the private servers. They do a little more. They go a little more than sheriff does. So if it's somebody has a kind of crazy work hour, but they are trying to avoid service, it may be worth hiring the private server. Next slide, please. Okay, this is my personal advice. Don't ask for any legal authority. This is based on my observation going to CHR petitions. And I'm sure people who handles everyday people have experienced this as well. The people want to tell you everything, whether it's related to the case or not sometimes, and they trying to tell you the background, and they are trying to tell you all the side stories and everything. And that's fine if it's during the consultation, initial consultation. But if they try to do that at the hearing, especially expedited processing like CHLO, they don't have enough time. They may miss the important things they need to say to convince the judge that they need a CHLO. So your job to tell the client what at issue, what kind of fact should be addressed, so what at point. So that's something alternative can help. And if you go to any hearings like the CHLO or small claim, you will see dozens of cases, and it's just half a day proceeding. You will know you're not going to have that much time to tell the judge everything. You're gonna have about 30, maybe you are lucky 1 hour. That hour should be also be divided to 2 parties. So you don't have much time. You have to be very organized and very concise.
It looks like
And
someone in the audience has their hand raised. Would you like me to
sure,
unmute
I
them?
don't see it here. Yes.
Susan, I just unmuted you I think I unmuted you.
I am so sorry. That was a mistake.
Oh,
Thank you
No
for the
problem.
attention, though.
no worries.
This is great info.
And I will, okay, maybe this is a good spot to tell you about the judge's discretion. And as I mentioned, the actual statute about CHR law is very skinny. And so judges, especially this is expedited proceeding, and many of them are proper layperson. So judge have a huge discretion. So, I mean, in any civil action, you cannot really predict the outcome. But in CHRO case, that variance is even bigger. So even one judge, so even the same judge can have some different outcome. For example, say a judge denied CHRO, even TRO, when a petitioner complained that the neighbor called the police on them multiple times. Calling the police is a protected right, First Amendment protected right. So you cannot restrain people from calling the police. So in that case, judge rightfully denied the request. However, in another case, the same judge granted roommate CHR petition where she complained her roommate called on her just once, not repeatedly, just once. But there's other thing was there. I mean, there was complaint about some trouble at about the refrigerator, and then the other roommate put a surveillance camera in the common area. So it looks like the judge wanted to find the hook to approve the CHR petition. The only hook she could find was the calling the police. So same judge granted the CHR saying the calling the police was harassment. So the judge's discretion is huge, and then sometimes in terms of evidence-wise, like hearsay or some copies of some email or screenshot, things that you can block, you can do a motion eliminate in general civil case, can get in. And those evidence rules are a lot looser, and there isn't much you can do because you can appeal the decision, and the standard of review for appeal in CHR is a abuse of discretion. You have to prove clear abuse of discretion. And as you may know, in appeal, that's not an easy burden to cross. So you have to be very careful when you tell your client how it's gonna end. So I shouldn't say more.
It looks like we have another raised hand. Is it okay for me to unmute them?
Yeah, sure.
Andrew.
Yes. You said that the standard of evidence is relaxed in a CHRO hearing. Can you give an example of how relaxed the courts allow? I mean, will they allow hearsay? Do they allow, declarations? How relaxed is this standard of evidence?
Exactly that. Here's the declaration. They bring a declaration from neighbors or some friends who are not there. So they have a signature and everything, but if in regular civil proceeding, if there's a declaration with a signature but no testimony, you can kick it out for hearsay. In CHR hearing, it may be get admitted, and judge may consider it. And a cynic, I mean, I'm kind of cynic, so how do you know that actually that person wrote it? But some judge will use it and have it admitted. So. And many times you will see kind of screenshots of many things and email, especially email. Actually, I have someone putting an email and I had to prove that email was doctored. She put the PDF shot of an email and then change the date and time. I had to prove it because that's doctored email. That's not something you can do easily, but that person made a mistake. They just send me the doctored version of the email, a PDF of the email, that I can see when and how she doctored it. But if they simply just brought the hard copy, I would have never known. I couldn't have been able to prove that was doctored. But she just emailed me the doctored PDF. So that can happen.
There's also one question in the Q&A
Okay.
that says, related to serving, if you are serving a couple or two people that live in the same household, do you need to serve each individually?
Well, you cannot file a restraining order against a group. You can have multiple protected person, but you cannot have multiple restrained people. It's against only one person. So if you want to file a restraining order against multiple people, you have to file multiple petitions. So yeah, you have to serve everyone separately. Next, please. Yeah.
I have a follow-up question. You mentioned that you had to prove that someone had doctored an email. And since I'm assuming that you don't generally get all the evidence or documents before the hearing, are you?
Oh no.
What?
I get the document before the hearing, but they usually mail me a copy in paper copy or bring the paper copy to the hearing. But this person emailed me those PDF file. So when you change something in PDF, there's a panel next to you showing all the changes made. That would still alive.
I guess what I'm asking is because in my experience in small claims court, everybody just shows up day of with their documents.
Yes,
and
that's
you were
very common.
drawing a parallel. So since you were drawing a parallel with small claims, I was drawing the conclusion that just like in small claims, people show up day of the hearing with their documents. So the opposing party. But are you saying that the opposing party is supposed to send you their documents beforehand? And how much beforehand are they required to send you your documents?
Actually, technically, they have to send it at least 5 days prior. But that's another discretion. Judges allow the same day submission all the time. As long as you have an extra copy to show it to the other side, judges allow it.
All right. And in that case, will the judge allow a continuance saying, hey, look, I've never seen this before. I need to prepare in response? I mean, how easy or fast or relaxed will the judge give you time when you are basically sandbagged day of trial or day of hearing?
Well, if you bring a copy to give it to the other side, and then the other side has a few minutes to review it, judge will allow it.
Okay, because all right. So basically, if you can get sandbagged at the hearing and lose the hearing because they produce something and you I mean, yes, you have some time to review it, but reviewing it and adequately preparing for it, like you said, establishing that this document had been doctored, that's not something that one can do in a few minutes. That takes.
That's correct. That's correct.
So what's the solution? Or are you just SOL?
If that person was smart and then just gave me the hard copy on the day of hearing, we might have lost the case.
And I guess my question is, what's your option? So are you saying there is no option? And that we have to prepare our clients that, hey, look, they may surprise us with documents and we may lose because they sandbag us?
I think so.
All right.
I mean, later, if you can prove they are doctored, you can appeal. So, but at the hearing, I don't think there is much option to avoid it. You have to deal with it as they come.
Okay, thank you.
Thank you. Next, please. Oh, there are Q&A. Hold on, please. About attorney's fee. Well, attorney's fee, there is a section asking for attorney's fee, and I haven't seen it being granted. So you can put attorney's fee in the petition, but you have to file a separate motion. Whether it's going to be granted, I doubt it. I haven't seen it, so I don't know. I don't think an entity can be restrained. Yeah, if the workers, then you can restrain the workers, not the entity. So, civil harassment restraining order is for against the person, not an entity. No, I don't think. Oh, if a judge denies CHLO, is the client who was seeking protection order to pay any cost or court fee for the respondent? I don't think so. I haven't seen it. I haven't seen anyone getting cost reimbursed, winning or losing. Can you appeal, or is it better to bring a case to reconsider? You should appeal if you have evidence to show clear abuse of discretion. You should appeal. This judge's discretion is the part gives so much on the problem. It's so much unknown, and it can be very frustrating to attorneys. So as far as I know, only option is filing an appeal when you get the evidence that something went wrong. Next page, please. Other restraining order, I mentioned briefly earlier. Domestic violence restraining order, it's close relationship. So there are people living in the same household, or so they don't have to be married, but they are living together. You can do a domestic violence restraining order. Unlike the civil harassment restraining order, you can have the aggressor move out through domestic violence restraining order, CHRO, have a section for eviction if that's the residence of the protected person. So you cannot have someone move out from a place you don't live actually. So you have to live, if you are living in a house and then the restrained person is living in the same house, then you can ask the court to remove the person. So that's a difference between, one of the difference in the remedy. And the criminal domestic violence restraining order, that's a totally different area. So I'm not gonna touch it. I don't do any criminal issue. So that's separate. And workplace violence restraining order. And as I mentioned, this is what employer files to protect their employees. So it's not the harassed employee do not file this. Harassed employee can file civil harassment restraining order, but the employer can file on behalf of the employee workplace violence restraining order. And it used to be just simply violence of threat and violence only. So the physical violence or threat of violence that's the only scope of workplace violence restraining order. But SB 428 expanded it. So now it includes harassment. So the scope is pretty much the same as the civil harassment restraining order. So if someone is harassing your employees through email, phone call, or website, the employer can file it on behalf of your employees. Elder abuse restraining order. This is a 65-hour order, and also dependent adult can file it. And just like domestic violence restraining order, this one also have eviction as a remedy. So if the elderly person is living in the same house with the aggressor, the restrained person, you can ask the court to evict that person from the house. But that's what's different from civil harassment restraining order. So if somebody is older, over 65 or has a mental or physical disability, dependent adult, then you may want to file elder abuse restraining order instead of civil harassment restraining order because it had a better protection and more remedy. Next, please. Second, audience poll. Yes. Okay. This last year, the answer was 1. Okay. But this year, there are 2 answers actually. First, since they are not living in the same house and they don't have any personal relationship, you cannot file a domestic restraining order. The boyfriend of your ex-boyfriend is not in a domestic relationship with you. So you can file a civil harassment restraining order. Actually, this is an actual event based on based on an actual event. So that actually happened. And yeah, then you can file a civil harassment restraining order, but you cannot evict that person through any of the restraining order. So you have to file an eviction to have the person removed. And you cannot file a domestic violence restraining order because you're not in any domestic relationship with that person. You're not that remaining one person is not your boyfriend or was the boyfriend or not related. So domestic violence restraining order is not an option. Workplace restraining order. Last year, it was not possible because there was no threat of violence or any physical harm. It's just email or posting on social media. However, because of SB 428, this person's your employer, that your client's employer can file a workplace restraining order against that remaining person. So the first civil harassment restraining order and the workplace restraining order are possibilities. Next, please. Oh, there's the Q&A. Okay, hold on. How often have you seen CHR denied for lack of evidence as opposed to denial based on inappropriate use? Oh, inappropriate use gets denied very straightforward. That's very quick. So if it's denied after a hearing, it's due to lack of evidence. But if it's for inappropriate use, it's gonna get denied right away. Which is more common? How often do I see? Quite often. I see roommate or landlord trying to evict the roommate or the tenant through CHRO quite often, very often. Because as you may know, eviction costs several $1,000s for landlord to do it, but CHRO hardly cost anything. So landlord try to use it, and the roommate, probably same reason. Oh, of course, they cannot do eviction, the UD anyway, but they try to use CHRO to evict their roommate. That happens quite often, actually, unfortunately.
I think that was the end of the slideshow. So we're just in the Q&A portion. If other people have questions, feel free to either enter them in the Q&A section, or if you raise your hand, I can unmute you to talk.
Okay. For clarity, to prevent invalid evidence from being accepted by the judge, we can object to it pending confirmation to prove its validity, but the judge still has discretion to rule on it regardless. Then after, if you have evidence to discredit the objection. Actually, you have an option to modify or terminate restraining order if you have a new evidence to do it. So before appeal, you can try to terminate or modify the evidence. So, but that is designed, that option is designed for change of circumstances, like you got a civil harassment restraining order against, your roommate got a civil harassment restraining order against you, so you decide to move out. So once you move out, you can have that civil harassment restraining order terminated. So you have that option. But if you have a special evidence, new evidence that can discredit key evidence, you may want to try that, yes. What's the most common way to find someone like the homeless person or defendant who moved? A homeless person, that's really hard, but as far as I know, even the homeless people have certain area they like to go. So you need to have some detective ability to do that. And someone you moved. Yeah, that's I don't know how to find people. I'm not expert in how to find people, but you can hire a private investigator, and especially, but that if the person has to move or have a job or things like that. But for homeless person, that's very tough. That's very tough. But as I said, as far as I know, homeless people have certain areas they like to go, they frequent. So, do you appeal with a petition? I never. Really? I don't know. I don't think. I never. No, I don't know. I don't know whether you can appeal the CHR ruling by reader petition. Sorry. What's the consequence of the granted CHR against a roommate if not eviction? But you want to move on? Yep. As I said, if roommate CHR is very common. So what common ruling is, the restrained person cannot go within 3 yards from the protected person. And if the restrained person see the protected person, they have to move away, and they cannot. And then the restrained person cannot talk, contact, get closer, things like that. So that's the most you can get. So you cannot get an eviction order at all, but you can have your roommate not talk to you, not send an email, not call you, not come near within 3 yards. So if that your roommate see you in a kitchen or someplace, and then they have to move away, that's what the restraining order will say. How does the restraining order affect a person day by day? Does it affect how suspect will show up? CHR will show up in background check, yes. So that's not something you want to have. And it can affect your job, even housing perspective, yes. It depends on how thorough the background check is, but it can easily show up in the thorough background check.
I think we can wait another minute. If people want to ruminate and type in any other questions or raise their hands. Just as a reminder, when you leave the Zoom, you'll be redirected to an evaluation form. For people who joined late, submitting that evaluation form what will prompt me to send you a certificate of attendance. So make sure to do that, and I will get those out, say by the end of the day tomorrow. If there are no other questions, I think we can wrap this up. Oh, look, there's one more question in the chat, in the Q&A.
Okay, can you object to statute of limitation? Yeah, with the statute of limitation, of course. I don't think there's any discretion in terms of such a limitation. Okay. And also, if it's really that something happened a long time ago, more than a year ago, and there's any chance it's going to happen again, judge will say no. There, you have to prove the future harm is going to happen if the CHRO doesn't get granted. So if there's something happened more than a year ago, judge will not probably consider it because there's a 1 year gap of nothing. So.
There's one more question in the Q&A. Says, you said an entity cannot be restrained. What if the boss of a company is ordering employees to harass someone else?
Then you can get a restraining order against the boss. Is ordering employees to be harass someone else? Yeah, then you can get a restraining order against the boss. So otherwise, I don't know, you cannot get a restraining order against the whole company because it's already a person. Do you have to state the date of conduct in your? Oh yes, date is very important. As I said, if something happened long time ago and nothing happened for an extended period of time, that's a good indication there's no probability of future harm. So date is very important. Judge will be very strict about when it happened. Okay, looks like that's it.
Last chance for questions.
And oh, I forgot to apologize. As you can tell, I have a very strong accent. I tried to get rid of it, but couldn't. So if you couldn't understand what I was saying, I'm sorry.
Your email was also on the slides that were sent out. So I think if you are open to it, people can contact you with
Yeah, feel free to send me
follow-up
an email if you
questions
have a
and so
question.
on.
Yeah.
But yeah, and I will be following up with everyone with your attendance certificates once you submit the form. And hopefully people who aren't already involved with the ALRP, I will also be bothering you a little bit to try and get you on board. Other than that, have a great afternoon, have a great rest of the week. And we will see you all around soon.